Hello and welcome to the third-party sponsors information video for the 43rd provincial election. The information shared is not considered legal advice by Elections BC and is based on our current understanding of the legislation. If in the future our understanding changes or laws or interpretation change, then the information provided in this training may not be applicable. The responsibility for compliance with the legislation rests with each individual and organization having duties under the Election Act. Therefore, if you require an interpretation of specific circumstances, you may wish to consider seeking your own independent legal advice. Please note you may hear the acronym EBC for Elections BC and TPS for third-party sponsor. This video will cover the following topics: Election Act amendments, regulated period timeline, registration, election advertising, authorization statements, advertising limits, sponsorship contributions, other rules and additional reporting, as well as monetary penalties. One main change for this provincial general election is legislation updates that were passed in 2023 under Bill 11. This Election Amendment Act clarified the independence requirements for third-party sponsors, updated the definitions for election advertising, and added specific misrepresentation and false information transmission prohibitions and penalties. We will go into details as to how these amendments specifically apply to third-party sponsors in each relevant section. The pre-campaign period advertising rules began on July 23rd and end on September 20th. The campaign period advertising rules begin the next day, September 21st, when the writ is issued, and end when voting closes at 8 p.m. on October 19, which is final voting day. We will further clarify both the pre-campaign and campaign period rules when we discuss election advertising. As a reminder, third-party sponsors, also known as TPSs, must be registered with Elections BC prior to conducting any election advertising in the pre-campaign or campaign periods. We encourage all TPSs to register as soon as possible to allow our office to process your registration so you may start advertising. As a refresher, any individual or organization other than a candidate, party, or constituency association that sponsors election advertising during the pre-campaign period or campaign period must register with Elections BC. Individuals and organizations that do not pay to create, produce, publish, broadcast, or transmit election communications are not required to register as a third-party sponsor. A third-party sponsor who sponsors election advertising with a total value greater than $10,000 must appoint an auditor. The TPS must give the auditor access to all records and provide any information necessary to complete their auditor report, which will be submitted together with the TPS financing report to Elections BC. As a reminder, third-party sponsors must be independent. They must not sponsor election advertising together with, nor collude with candidates, political parties, constituency associations, and their agents. The 2023 Election Act Amendment Act provided further clarity on the definition of independence. For clarity, Campaign collusion involves two or more independent political entities knowingly working together to gain an advantage during an election that would not otherwise be available to them if they were operating their campaigns alone and/or whose activities are intended to circumvent the legislated provisions. Please see the guidelines on independence and collusion requirements for third-party sponsors handout on the Elections BC website for a comprehensive list of the criteria used to assess if an individual or organization is in fact independent when applying for third-party sponsor registration. For example, someone who resides with a candidate and is a spouse, parent, child, or relative of the candidate or a candidate's spouse is not independent and may not act as a third-party sponsor. Once registered, third-party sponsors remain registered between elections. Since registration as a third-party sponsor is ongoing, third-party sponsors are required to notify Elections BC if there are changes to their registration information. Registration updates must be sent using Form 422 to Elections BC within 30 days after a change has occurred. Changes include updates to the name of the sponsor, general contact information, and the residential address of the principal officers and members. This information is important as it is used to verify the independence criteria outlined previously. To update your registration information, complete Form 422, which is available on our website or can be requested from our office, and submit to Elections BC by email, fax, or mail. If your registration update is complete, Elections BC will update your information. If more information is needed, we will contact you and explain what is required. Pre-campaign period election advertising is defined as the transmission to the public by any means of an advertising message that is sponsored by a third-party sponsor and directly promotes or opposes a registered political party or the election of a candidate. Campaign period election advertising is defined similarly. However, it includes indirect messaging and issue advertising, as highlighted on the screen. The definition is as the transmission to the public by any means during the campaign period of an advertising message that promotes or opposes, directly or indirectly, a registered political party or the election of a candidate, including an advertising message that takes a position on an issue with which a registered political party or candidate is associated. Additionally, election advertising includes the following activities if conducted on a commercial basis: canvassing voters in person or by telephone or other means of electronic communication to influence how they vote, and mailing or transmitting on the Internet material that contains advertising messages. Please note the 2023 Election Act Amendment also updated the definitions of election advertising. Previously, social media posts were only considered advertising if there was a placement cost. Now it can be considered election advertising if posts are paid, sponsored, or promoted to reach a wider audience. Even if the post is not sponsored or promoted, a message may be advertising if money has been spent to increase transmission of the post, or an individual or organization has been paid to publish the post. The Act exempts certain communications from being regulated as election advertising. Examples of communications that are not election advertising include the publications without charge of news, an editorial, interview, column, letter, debate, speech, or a commentary published without charge in a bona fide periodical, on a radio or television program, or in a bona fide internet publication or program. The distribution of a book or the promotion of the sale of a book for no less than its commercial value, if the book was planned to be made available to the public regardless of whether there was to be an election. The transmission of a document directly by a person or a group to their members, employees, or shareholders. The transmission by an individual on a non-commercial basis on the Internet, or by telephone or other means of electronic communication of the individual's personal political views. A communication by the government necessary for carrying out the proper function of the body. During the pre-campaign period, the following criteria are used when determining if a message is election advertising. Was the message transmitted to the public by any means? Was the message sponsored by a third-party sponsor? Did the message directly promote or oppose a registered political party or candidate? Did you pay for or receive a service free of charge in the creation or dissemination of the message? Similarly, during the campaign period, the following criteria are used when determining if a message is election advertising for not just third-party sponsors, but also candidates and parties. Was the message transmitted to the public by any means? Was the message sponsored by a third-party sponsor, candidate, or party? Did the message promote or oppose, directly or indirectly, a registered political party or candidate? Did it take a position on an issue associated with a registered political party or candidate? Some indicators that advertising and activities are election advertising include references to the election, voting, the date of final voting day, your choice, make your choice heard, etc. Advertising specifically planned to coincide with the pre-campaign or campaign period or a material increase in the volume of advertising. Indicators that advertising and activities may not be election advertising include advertising or activities that are necessary for the performance of a member of the Legislative Assembly's duties, or advertising that the public would reasonably expect during the relevant time of year and is consistent with previous advertising conducted by the sponsoring person or group. If you are not sure if a message or activity is election advertising, please review the Election Act. If you require greater certainty, you should obtain independent legal advice. The following are used to determine who the sponsor is. The individual or organization that paid for the election advertising. For example, if an individual or organization pays for materials such as bumper stickers, T-shirts, or signs to be produced, that person is a third-party sponsor, not the person who wears the T-shirt or posts the sign or bumper sticker. If the services of conducting the election advertising are provided free of charge, the individual or organization that received the free advertising. A reminder that an individual or organization must not sponsor election advertising with the property of any other individual or organization or indirectly through any other individual or organization. For example, if an organization pays to produce election advertising lawn signs promoting a specific candidate, the organization is the sponsor, not the person who posts the sign in their front yard. Please note, media organizations and social media platforms that transmit election advertising are not required to register as third-party sponsors, but they must not publish election advertising unless the sponsor is registered. Election signs may be placed or removed on private property at the discretion of the property owner, subject to municipal or other bylaws. Election signs must be allowed to be placed within the premises to which a renter's tenancy agreement relates and must be allowed on the premises of a strata unit. However, landlords, strata corporations, and their agents may set reasonable limits on the sizes and types of election signs which are permitted and may restrict placement in common areas. Those canvassing on behalf of a TPS on a commercial basis must identify the sponsor's registration under the Election Act, and their authorization from the sponsor to canvass. During a campaign period, the 100 meters around the district electoral office is a restricted area where individuals and organizations must not post, display, or disseminate any campaign period advertising or any material that identifies a candidate or registered political party unless authorized by the district electoral officer. Likewise, while advance or final voting is being conducted, the 100 meters surrounding each building that contains a voting place is a restricted area. If these rules are contravened, the district electoral officer or another election official has the authority to enter the property where the materials are located to remove or obscure these materials. Individuals and organizations must not transmit to the public campaign period election advertising on final voting day before the close of all voting stations. However, there are exceptions that can be found on the EBC website, such as a notice of an event that a party leader will be attending, an internet message that was posted before final voting day and will not change until after the close of voting, or an internet message with the sole purpose to encourage voters to vote in the election. Generally, all election advertising starting from July 23, 2024 must contain an authorization statement which identifies the sponsor, indicates that the sponsor is registered, and provides a BC telephone number, mailing address, or email address where the sponsor can be contacted. Email addresses allowance is new for this election. Both individuals and organizations can use email addresses. You can see a couple examples on the screen. Please note, third parties must include the sponsor's name and specify that the advertising was authorized by the sponsor. For messages that are sponsored by more than one sponsor, each sponsor's authorization statement is required. The authorization statement is not required for election advertising on clothing, novelty items, stickers, buttons, pens, mugs, magnets, etc. Some forms of online advertising, such as a website or banner ads, may not have room for an authorization statement. In this case, it is sufficient if one click on the ad sends the viewer to a website, landing page, or profile page that contains the sponsor's required authorization statement. Please ensure that your authorization statement is clearly visible to the public. If it is not visible, members of the public have historically called EBC and filed a complaint. Non-compliant advertising can be removed and/or destroyed, and the sponsor subjected to administrative monetary penalties up to $10,000. The value of election advertising is the price paid for preparing and conducting the advertising at the current market value, including all taxes and fees. Services provided in relation to ongoing activities by a sponsor to their own campaign or by existing staff to the organization are considered to be overhead and are not included in the value of election advertising. However, The value of services used to prepare and conduct election advertising must be included in the value of election advertising if the services are purchased or received from an outside vendor. Third-party sponsors are subject to advertising limits. Advertising limits for the 2024 provincial election apply to the value of advertising expenses used by the sponsor during the campaign period, which runs from September 21st until voting closes on October 19th. Advertising limits are calculated on the day an election is called based on changes to the Consumer Price Index. The screen shows the current estimates, and the final limits will be published on September 21st. Advertising that promotes or opposes a specific candidate or political party in an electoral district, or advertising in relation to an issue that is specific to that electoral district, is counted towards the advertising limit for that electoral district. Otherwise, advertising expenses are generally counted towards the overall limit. A third-party sponsor whose advertising expenses exceed the applicable expense limit is subject to penalties. A contribution includes money, property, or services given without compensation by an eligible individual to a third-party sponsor. A sponsorship contribution is provided specifically for election advertising. It must include confirmation and consent, Form 4021, so the TPS may use the amount towards their election advertising. A contributor may provide confirmation and consent at the time the contribution is made, or up to 24 months after the contribution. If a contributor does not provide this agreement, the donation cannot be used by the third party on election advertising. Please note, when collecting contributions online, the value of the contribution is the full amount provided by the contributor. Any associated costs or fees deducted should be recorded and reported as expenses. For example, if a contributor pays $100 online and the platform charges a $2 fee, the contribution will still be recorded as $100, not $98. Sponsorship contributions can only be accepted from eligible individuals, meaning a resident of BC and a Canadian citizen or permanent resident. Corporations, unions, and organizations cannot make sponsorship contributions. Third-party sponsorship contributions must be made using an individual's own money or property. Contributions cannot be made indirectly with the money or property of another person or be reimbursed by another person. When making records for your contribution data, ensure that you record full name, amount, date, and residential address. Only one name should be provided for each contribution. If you have a check with two names on it, clarify which person the contribution is from or report it as two separate contributions if it's from both. The sponsor is required by the Election Act to record this information and to retain it for at least 5 years. Elections BC may request these details as a part of their review process at any time. If a third-party sponsor becomes aware that a sponsorship contribution was made or accepted in contravention of the Election Act, the sponsor must return the contribution or its equivalent value within 30 days. If a third-party sponsor is not able to comply, they must not use the contribution to sponsor election advertising. Annual contribution limits are updated every January, and the limit for 2024 is $1,450.82. An eligible individual may contribute up to the limit to each third-party sponsor. That being said, if 2 or more third parties sponsor election advertising together, they cannot use more than $1,450.82 from a single contributor. For example, if 2 third parties are going to share a billboard, the total amount of money used towards the billboard from a single contributor cannot be more than $1,450.82 in total, even if the contributor donated separately to each TPS. For valuing advertising expenses, the value of any property or services is the price paid for the property or services, or the market value of the property or services if no money is exchanged or the price paid is lower than the market value. There are also limits to anonymous sponsorship contributions. Anonymous contributions must be truly anonymous. A contributor cannot ask to have their contribution be anonymous. Anonymous sponsorship contributions must be $25 or less, and a third-party sponsor cannot use more than $250 in anonymous contributions to pay for advertising related to a single electoral district, or more than $5,000 in anonymous contributions to pay for advertising overall across the province. Anonymous sponsorship contributions do not require contributor confirmation and consent. Reminders: cash contributions must be $100 or less. Contributions over $100 must be made by check, money order, credit card, or electronic transfer. Third-party sponsors must open a sponsorship bank account in a savings institution if they receive more than $10,000 in sponsorship contributions. Once this $10,000 threshold is reached and the sponsor opens the sponsorship account, they must transfer all sponsorship contributions that have not already been spent to this account within 7 days, and deposit all future sponsorship contributions into the account. Payments for election advertising must then be paid from either this account or from the sponsor's own assets. In addition to the amounts required to be deposited after opening a sponsorship account, the following deposits may be made to a sponsorship account: other assets, permissible loans, interest on amounts deposited in the sponsorship account, and dividends paid on the sponsorship account if the account is at a credit union. Third-party sponsors may use some of their own assets to pay for election advertising. They may use money derived from membership fees or ongoing operations, such as selling goods or services, but they cannot use money that was received as a general contribution unless the contributor provides their confirmation and consent to turn it into a sponsorship contribution. Remember, you can go back 2 years to obtain the confirmation and consent agreement to turn a general contribution into a sponsorship contribution, meaning confirming the contributor is an eligible individual and that they give their consent for you to use their contribution on sponsored advertising. There are other rules that apply to third-party sponsors. They may obtain loans from a savings institution to pay for election advertising, host fundraising functions to raise sponsorship contributions, including by selling tickets to attend and conducting auctions, sponsor advertising in combination with other third-party sponsors. That being said, these activities are uncommon for third-party sponsors. Please call our office if you plan on doing any of these activities, and our staff will assist you in understanding the requirements. Please note, a permissible loan to a third-party sponsor is not a sponsorship contribution and can only be provided by a savings institution with a non-preferential interest rate. A third-party sponsor must not accept a loan other than a permissible loan. Debt may become a sponsorship contribution if the debt is unpaid for 6 months after the due date and the creditor does not make reasonable efforts to recover it. Third-party sponsors also have additional reporting obligations if they sponsor more than $10,000 in election advertising. Once this threshold is reached, an initial disclosure report must be filed with Elections BC within 14 days. The report discloses sponsorship contributions from eligible individuals who gave more than $250 in total to the sponsor. A third-party sponsor may need to file a subsequent disclosure report within 14 days of receiving a sponsorship contribution from a contributor who makes one or more sponsorship contributions that have a total value greater than $250 since the date of the initial report. The sponsor must file subsequent disclosure reports until final voting day. Third-party sponsors who sponsor election advertising with a total value greater than $500 must file a third-party sponsor advertising disclosure report with Elections BC. This report must be filed within 90 days after final voting day. The Election Act prohibits false statements, transmission of unauthorized material and information, and misrepresentation. These have been in place since May 2023 and have serious penalties. These rules apply during the pre-campaign and campaign periods, and EBC's disinformation regulation is limited to the following categories: false statements to affect election results. These include statements related to the citizenship, place of birth, education of candidates, false statements about election officials and voting administration tools. These include misinformation that relates to an organization that provides voting administration tools to EBC. False election information. This includes misleading information about voting options and voting opportunities, and unauthorized material or information. This includes information that purports to be transmitted by the Chief Electoral Officer, or Elections BC. The regulations have provisions that the statements are intended to affect election results by making the false statement, and that the individual or organization knows the statement is false, or has a reckless disregard as to whether the statement is false. Note that the new regulations for misrepresentation are in effect regardless of the period. Misrepresentation is when an individual or organization falsely purport to be a candidate, political party, constituency association, or an individual authorized to act on behalf of these entities. These prohibitions apply in relation to an election. Parody and satire are exempt from these prohibitions. For further details on the specifics, please visit our website or contact us with any questions. The Election Act establishes significant penalties for contraventions of the Election Act. Monetary penalties can be administered for conducting advertising without registering first, failing to include your authorization statement, exceeding limits, contravening sponsorship contribution rules, and disinformation. For contravening the sponsorship contribution rules, your contributor may also be issued a monetary penalty. As a refresher of the process, if we learn that non-compliance may have occurred, we'll reach out to you to clarify the situation, and you'll have an opportunity to respond before a determination is made. Non-compliance issues are reviewed by the investigations team at Elections BC. When a monetary penalty is issued, a notice of non-compliance is published on the Elections BC website and in the BC Gazette. These notices provide information about the offense and the actions taken by the non-compliant individual or group to fix the situation. For more information on the penalty determination process, you can visit our website. Thank you for viewing this video, and if you have further questions, please be in touch.